Hello, I'm going to give a presentation on the impact of COVID-19 in Argentina and the measures enacted by the government as a consequence of COVID-19 and the tools that are applicable under Argentine legislation to cope, to deal with the legal and factual situations emerged as a consequence of COVID-19. So I will try to make this swift. So this pandemic, this crisis got Argentina, with some time. So when we saw the news from Italy, the government immediately on March 16 decreed a preventive and mandatory isolation, the quarantine. And so basically from March 16, they sent everyone home, a total lockdown. This has helped before any wave of virus. This has helped Argentina to deal and be as far as so far quite successful with the management of the coronavirus crisis. The first thing the government did was to prohibit suspensions and dismissals, so as to protect labor. Our economy is not as flexible, as modern as the U.S. economy, so they wanted to protect the workers and not the companies. If the companies go bankrupt, it's their problem. We don't want to have employees dismissed or suspended. Also, they have froze the price of lease agreement and suspended eviction. And of course, most activities, hotels, theaters, shopping centers, etc., have been suspended. Now, there are, tons of regulations every day about, which activities are permitted, which activities are not permitted. They started with allowing only essential activities. Like health, pharmacies, supermarkets, grocery stores, convenience stores, and they have slowly eased these regulations and included more essential activities like construction, related to construction and so on. But this emergency triggers a number of economic shortfalls and the impossibility to comply with certain obligations on parties and the reduction of income for everyone. So what institutes, what tools do we have under Argentine legislation to deal with this health emergency? What are the guidelines to face the situation, and how can we deal with the potential cases? I will very briefly mention three institutes that are in our civil and commercial code. First, the force majeure. Secondly, the uncertainty theory. And thirdly, the frustration of the purpose. The application of each institute must be requested by the parties or parties. And this institutes, and it shall be proven that these events are extraordinary, unpredictable, and out of control. I will mention my experience. I've been renegotiating contracts for hotels and companies, and no one disputes the fact that the COVID-19 emergency is a force majeure event. No one. It's been declared by the government officially, and there is no opinion to the contrary that this pandemic is in fact an event of force majeure. Now, I will, without further ado, I will go to the force majeure definition in our civil and commercial code. Force majeure is a fact. it should be objectively unpredictable and unavoidable. It must not be attributed to the parties. So if I burn my warehouse, I cannot use force majeure protection. It must have happened after the legal relationship was agreed. So it must have happened after the contract was in place, and it should produce the impossibility to comply with the obligation. If this happens, one can say, look, we are in a force majeure situation, we have to renegotiate. The effects of force majeure is that the debtor is released from complying with his or her obligations agreed contractually or otherwise. And if the impossibility is definitive, so I will never be able to comply, well, I'm released of my obligations without the right of any compensation on the other party. If it's a temporary impossibility, so I cannot comply now. So, for instance, in the case of hotels, in some cases we could renegotiate and say, okay, you cannot come today, but you can come in 3 months, 4 months. But in other cases where it's a definitive impossibility, well, then you are not liable to comply forever. But if it's a temporary impossibility, the obligation may be performed later without any liability due to the delay. So no interest or penalties to be paid because of this frustration. It applies to all agreements with pending obligations, and it must, like all the other institutes that we'll discuss, can be invoked out of court as a claim of defense or in court. Now, the uncertainty or the imprevision, unpredictability, even when the obligation could be accomplished with the existence of the new and unpredictable events, some events that were not foreseen, that were not possible to predict, forbid the parties from complying with their obligations, or they render the obligation extremely onerous. Hardship related to the fulfillment of an obligation may occur when it increases the sacrifice for one of the parties without the same retribution, or when the sacrifice remains the same, but the retribution ceases, or when both values are altered in a reversed way, which affect negatively the inner balance, the inner balance of the contract, of the agreement, the economic balance of the agreement. The effects are a complete or partial termination of the agreement, or the adequation of the agreement to the current situation. This applies to onerous cumulative agreements of deferred or permanent execution, or aleatory contracts of deferred or permanent execution, where the hardship comes from facts not contemplated within the uncertainty accepted by the specific agreement. Like force majeure and uncertainty can be invoked either out of court or as a claim or defense, or in a lawsuit as an attack or as a defense. Now, the third institute I'd like to briefly mention is the frustration of the purpose. The Civil and Commercial Code provides that the definitive frustration of the purpose of the agreement entitles the damaged party to declare determination. Such frustration must be originated by an extraordinary alteration of the existing circumstances at the time the parties entered into the agreement, and such alteration must be caused by events that are out of the parties' control and exceed the risk assumed in the relevant agreement. The effect, the termination of the contract, applies to agreements that have a specific purpose expressly or implicitly included in the agreement. Now, as a general rule, and this, I will say, I have had to renegotiate in this month agreements with force majeure clause and without force majeure clause. In both cases, we have agreed that we are in a force majeure situation and that we have to renegotiate. And we renegotiate in good faith. This is the guideline for any negotiation. Always the good faith. So one has to begin as soon as possible the discussion and the discussion in good faith with the other party. Regarding, like I said, regarding the tools, force majeure, uncertainty, and frustration of the purpose, one must, as soon as possible, say, look, we are not going to comply. I want to tell you, like I will give you one example. We had an event scheduled in a big hotel here, $500,000 contract, big congress for 400 people in Buenos Aires, and we had to cancel because of the virus, because people is not traveling, you know, the borders are closed and so on. And we immediately told the hotel, and we said, look, we have to move this. Give us, we are in force majeure, give us back the money, please. And we're gonna, you know, reschedule this. And you can use the dates we had for other things, for weddings, or for, you know, for someone locally, for all those weddings that you had to reschedule that were going to happen in March. You can reschedule them later for when our event was going to happen. So you can use this, but it's very important to collaborate, to communicate, and to use to use good faith as a basic guideline. Now, our advice is that one should review each agreement, the terms of compliance, the applicable law, the exist, because not always, you know, not always Argentine law applicable, the existence of insurance, be open with the other party and exchange information, take measures to reduce future damages, offer cooperation, offer them help, and try to reach an agreement. It's always better to have an agreement. So in force majeure, there's nothing, you know. There's no liability. You know, in our case, you have to give back the deposit, and so be it. You know, and we have to see, you know, maybe there are penalties or expenses that is subject to negotiation, but that's the case. In frustration of the purpose scenario, it is the same. In case of uncertainty, it is the same, but one could also agree to reinstate the balance of the agreement. Now, this is in general. Of course, the government, for some mandatory, you know, for some sort of public things like credit card loans or loans granted by financial entities, have issued regulation basically saying credit card debt are extended and loans cannot be increased. And in this case, there was no need to invoke any, you know, force majeure or uncertainty, because this was regulated by the government. One has to do the analysis on a case-by-case basis. I will, to end this presentation, I'm already over 13 minutes. I will mention finally that Section 79 of the Vienna Convention on the UN Convention on Contracts for International Sales of Goods provides that a party is not liable for failure to perform any of his or her obligations if he or she proves that the failure was due to an impediment or an act of a third party beyond his or her control, or that he or she could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. The party who fails to perform must give notice to the other parties of the impediment and its effect on his or her inability to perform. So clearly, Section 79 of the Vienna Convention, of the UN Vienna Convention, provides for force majeure. This institute provided in the Argentine National Civil and Commercial Code is provided, like I said, in the Vienna Convention, but it does not include uncertainty. For example, increasing prices due to local inflation shall not be applicable. So these are a few comments on the pandemic. For Aliant law, we are Canosa Abogados. We are members of Aliant in Argentina. And we hope we could get over this pandemic as soon as possible. So good day to you, and let me know if you have questions or queries. Best regards.